presentations, and also I have the dubious distinction that I do expungements about once a month. So I actually do these regularly, so I do have some experience in the area. The first thing that I want to do is just briefly introduce myself. So I was appointed to the bench in May of 2014, and I'm an associate circuit judge. And that's where we do our expungements in Jackson County, is at the associate circuit level, as part of our drivers or refusal docket. And I'm a trial court, so that means that I'm the first level. I'm not an appellate court. And I hear a wide variety of cases. Right now, I'm on a civil and domestic assignment. And then as of January 1st, I'll be going back on a criminal assignment. Interestingly, expungements are civil cases, so I only handle those when I'm on a civil assignment. All right, the one I want to talk about first, we're going to talk about 3 main statutes, and those are available to you at the back of the room if you'd like to pick one up and kind of go through it as I'm talking about it. The first one I want to talk about is for arrest records. So you can petition for the expungement of an arrest. You have to include in that petition the complete identifying information for yourself and for that arrest record that you want to expunge. So the more information you can include, the better. The idea behind that is when I enter an order, I want to include as much information as I can to help the agencies find the correct arrest record and expunge it. You also, only for this type of expungement, need to file a fingerprint card. So do some investigation about how to get the card. And you need to name every agency or court or any place that record could be held, because my order will only affect the entities that are listed. Because when you file the case, our civil records office sends notice to every agency that's listed. And if you don't list an agency, they don't get notice and my order doesn't apply to them. So when I see pro se expungements, that seems to be the thing that people miss the most. Is if I were you, I would think I would check every box just to cover all my bases and make sure that I'm getting it expunged everywhere it could be. And then also, I looked this up yesterday. The filing fee currently is $112.50. So this is not cheap. So make sure that you do qualify before you pay to file an expungement petition. We have petitions available statewide. This is what the petition looks like to expunge an arrest record. And the findings that I need to make are within that big paragraph there. And we're going to talk about those in a moment. And you can see at the bottom, all of the identifying information you need to include about yourself and about the offense. And then at the top are all those check boxes I was talking about. So all the agencies that you want to expunge the arrest record need to be checked and filled in up there at the top, or they're not going to get notice and it's not going to apply to them. The second page of this petition, you need to do a notarized signature because you're swearing that everything you put in this petition is true. And then the instructions to clerk are that they're going to send a copy to the prosecutor. They're going to send the petition and fingerprint card to the criminal record repository and give notice to all the agencies that you listed. So that's why you need to list them. We don't often get responses to these. Where I usually see responses are from the Missouri Criminal Records Repository, and now sometimes from the prosecutor's office. But usually the summons goes out, there is no response, and then I go ahead and have a hearing on the petition to expunge the arrest. And what I'm looking for in the hearing is for you to testify to essentially the same things that you're putting in your petition. When you testify to those things under oath, then you've basically carried your burden of proof, and it's up to the other side to come back and say, no, you're wrong, this doesn't qualify. And these are the things you need to establish: that the arrest was based on false information, there's no probable cause to believe you committed the offense, that no charges were pursued as a result of the arrest, so you weren't charged with anything. There's no later convictions at all. You haven't been convicted with a felony or misdemeanor since this arrest happened, or prior felony or misdemeanor convictions. You did not receive any SIS probation as a result of the arrest, and there's no civil action pending because of the arrest. And if you can carry that burden, then I would enter an order granting you that expungement. Any questions specifically on arrest records? Yes.
Thank you, Judge. Are there limits for like quantity of these, and can you apply to multiple?
I don't remember. Any of my expungement attorneys know that for arrests? There are definitely limits for convictions. I don't remember off the top of my head if there are for arrests, but that's a great question. And I wish I could answer you. Oh, how do you affect service in an expungement? You don't. You check the boxes of all the people that or all the agencies that you want to have this apply to. And then the clerk's office sends out notice to those agencies. And when I hear the case, I look to make sure that the notices all went out. Rarely we will get a response. Usually I do not. And then I go ahead and take the case up. So you just need to check the boxes for all the people that you want notified. I'm going to move on to probably what you're more interested in, which is the expungement of convictions. So that's another statute that's there at the back of the room, that's 610-140, and it frequently gets amended. It was most recently amended in August of 2021. Obviously, with the new marijuana law, we're going to see more changes to expungements. We don't have a great scheme in place right now in Missouri for how that's going to happen, because this affects a lot of people. There's going to be a lot of petitions for expungement. And right now the courts are trying to figure out how we're going to allocate staff and money and resources to identify the cases that are eligible for expungement. So right now I'm going to talk about the statute as it currently exists, or it existed as of August 28th of 2021. This is somewhat similar to the arrest expungement statute. The court can order agencies that have records of the arrest, plea, trial, or conviction to close those records. Again, you need to identify every agency that you want to get notice by checking the box, because if they aren't given notice, then my order doesn't affect them, and that particular record won't get expunged. Here, it's even more expensive. So the filing fee is $112 plus a $250 state surcharge. The judge can waive that surcharge if you file what's called a motion for informa pauperis, which is really just an affidavit in support of a request to proceed as a foreperson. And we do have those available on our website. But you have to fill that out with your income and expenses and your assets and debts. And the court then makes a decision about whether you can afford the filing fee or not. I don't often see people filing those. So usually people do go ahead and pay the full fee, which can be very expensive. And I just ran into this 3 weeks ago where I had somebody that paid the full fee, but they were never eligible for expungement to begin with. And so unfortunately, that was a very expensive mistake. Our clerk's office, they are not trained and qualified to give you legal advice. So it is you as the filer that needs to do some investigation to determine whether you are eligible for an expungement or not before you file. That particular person was very upset that they had been allowed to file when they were not eligible, but our clerk's office just doesn't have the ability to screen every case to determine eligibility, nor is that their role. So even if you are filing on your own behalf, you need to do that research. This petition looks a little bit different. This is the state petition for expungement of convictions. Again, you see at the very top, the list of all the defendants that could possibly have records. You should check all the ones and fill in all the ones that you think might apply to you. It also, in that big paragraph, states that all the different elements that you have to show to get an expungement. And I'll go through those in a little more detail in a moment. Again, you need to include your identifying information so the records can be located, because especially before records were electronic, it can be hard to find paper records. If they're very old, they may be archived somewhere. So the more information you can provide, the easier it is to find the record to expunge it. And then this is the second page of that same petition. This is where you would list everything that you want to be expunged. And then again, you would sign it, and you're stating that everything in there is true. So looking at what you need to show, you need to list all the offenses that you want to be expunged in your petition. The offenses have to have occurred in Missouri, and they need to be prosecuted in the county where your petition is filed. So make sure you're filing it in the right county. If you have like an information that charges 5 offenses, maybe 2 felonies and 3 misdemeanors, you can list every charge in that one charging document, that one information or indictment, and that counts as one expungement. And that's important, and the highest level charge is what it counts as. So it would count if you had 2 felonies and 3 misdemeanor charges in one document, that counts as one felony expungement. And that's important because there is a limit, like you pointed out for this, on the number of expungements that you can get. You're entitled to 1 felony and 2 misdemeanor or municipal ordinance violations. So it's important to list every charge that you want expunged from that same charging document in one expungement. There are a lot of offenses that are not eligible for expungement, and I'm sorry that I had to fit this all in. This is in the statute handouts that you can receive in the back as well. Essentially, just as a summary, if it's an A felony or a dangerous felony, a sex offense, something like that, something where death is an element, you're not eligible for expungement. And then where people get tripped up really is the list of all these section numbers. So you need to look at your charging document and see what section you were charged under and cross-reference it to see if it is a non-expungible offense. And the ones I see most often are crimes of dishonesty is how they're kind of referred to. I'm talking about forgery, stealing, things like that. Even though they're lower level felonies, they are not eligible for expungement. So if you're convicted of a fraud or a stealing, those are some of those section numbers that are listed. So make sure that you're looking at your original charging document or what you pled guilty to and see if it's in that list. Also not alcohol related, because we're going to talk about that in a moment. We have a separate statute for alcohol related driving offenses. So the takeaway here is make sure that you're checking to see if you're eligible before you file your petition. When you come in for the hearing, if you're represented by yourself, I'm going to ask you questions. If you have an attorney, your attorney will question you on the record under oath. And I need to determine whether all the criteria for expungement have been met. The time frames used to be longer. They've been recently reduced. So it has to be at least 3 years if the offense is a felony, or at least 1 year if the offense is a misdemeanor or a municipal offense or an infraction, since you completed the disposition imposed. So let's say you pled guilty and were put on 3 years probation. And it's for a felony. It has to be at least 3 years since you completed your 3-year probation, not since you pled guilty. You also have to show that you've not been found guilty of any other misdemeanor or felony, not including violations of traffic regulations. And a lot of times what people do is file their criminal history when they file the expungement, particularly if they have an attorney. You have to show that you've satisfied all obligations related to the disposition, including the payment of any fines or restitution. I had to deny one recently where she'd been unsuccessfully discharged from probation. And the reason was she had not paid any restitution, and it was right there in the discharge. So because that was laid out in the record, I couldn't grant her the expungement because she had not satisfied all obligations related to the disposition. You cannot have any charges pending, and you have to demonstrate that your habits and conduct show that you're no longer a threat to the public safety of the state. Okay. So the way you do that is by testifying about how your habits and conduct have changed since the offense was committed. So you might testify that you've, depending on the type of offense, that you've been through maybe a treatment program, or now you are working and supporting a family and you've no longer associated with the same people, that type of thing. Just a conversation about what you have done that has changed your situation since you had the conviction. And then I have to make a finding that the expungement is consistent with the public welfare and interests of justice warrant the expungement. Let's see. Okay, we're going to move on to driving offenses, but before I do that, does anybody have questions on the conviction part? The 610. Yeah, go ahead. Well, if it's charged in one charging document, it can be several different charges. You need to list all the charges from the charging document. And my attorneys that do this frequently, can you list like up to 1 felony and 2 misdemeanors in the same expungement? Do you know? Yeah, okay. So as long as you're under that lifetime limit, you could list them in the same expungement.
As long as they're from the same county.
Okay, yes, that's true. It always has to be from Missouri and prosecuted in the county. So as long as it's prosecuted in Jackson County, you could list those. Great, thank you for bailing me out. Yes,
So what is the exception? For the same course of criminal conduct, do you ever get tests for that?
usually, I mean, if it's charged in the same charging document, that's a pretty good indication it might have been the same course of criminal conduct. I don't have a great test for that, unfortunately, but I do. If I get a response from the Missouri State Highway Patrol or the prosecutor's office, they help me flesh that out. If I have to do my own investigation, I will do my best to try to dig through and see if I can find the charging document and the conviction myself. Sometimes with these really old cases, like people come in and ask for expungements for something that's 30 years old. I can't even find it in my system. So somewhat I have to rely on the information I'm getting, the sworn information I'm getting from the petitioner to make sure that they are eligible for that expungement. Unfortunately, our records are not that detailed, and there's a limit to what I can find sometimes. Any other great questions? Yes.
So not satisfying all the obligations of this position. I mean, if you're unsuccessfully discharged from probation, I would assume that you didn't satisfy all the obligations. So if you're unsuccessfully discharged from probation, pretty much categorically not going to get that expunged.
Well, in that particular case, I granted her a 2-month continuance and I offered to give her time to pay the restitution. Because it was clear in the document, the guilty plea document, who she was supposed to pay it to and what the amount was. And what happened was she just never showed up again. So I guess I assumed that she decided not to pay the restitution, but all it says is satisfy the obligations. It doesn't say if it has to be before or after discharge from probation. So in that case, I was willing to give her an opportunity to try to satisfy the obligation. It just never happened.
So do you think like the same rule would apply, like if somebody had to do community service or something, and they just like did not complete it?
Yeah, I mean, I think that would be an obligation of probation. So I think that an argument could be made that they don't qualify for expungement. Yeah, but my personal preference would be then to give them an opportunity to perhaps show me that they've done the community service, and then we could proceed with the expungement. I've got a couple online questions. What if charges originated in one county and there was a change of venue to another county? Do you go to the county it's charged in or convicted in? That's a great question. I think it has to be the one, It just says the one where it's prosecuted. What do you guys think? I mean, it could be, I guess you could argue it was prosecuted in either county because it was charged in one, convicted in the other. I mean, there was prosecution in both counties at some point, but I guess I'd probably go to the county where where you were convicted of it, because that's the county where you'd more likely have the records, I would think, of the conviction. Yes. No, it's more just, I think it's age, because before we went to online filing, we literally had paper files that we kept in filing cabinets and boxes. And if they're really old, some of them are in caves, literally. So, I mean, it's just, and they've gone back and tried to scan in some of those, but if it's an old conviction, it can just be really difficult to find. Yeah. You do. And we do the best we can to try to find the conviction. And if you can include as much information as possible, I generally will grant the expungement. So I don't want you to think that just because I can't find the conviction doesn't mean you're not eligible. Hopefully you can provide enough information about the conviction that it can be removed from your record, even if I can't physically find the actual document. Any other questions? Okay. Okay, I guess we'd like to save any more questions for the end. I'm getting to the end here. The last one I want to talk about is expungement of alcohol-related driving offenses, and that's section 610.130. This has to be an expungement of your very first alcohol-related driving offense. You can't get expungements of later offenses. And it has to be a misdemeanor or ordinance violation, which typically is the case for your first alcohol-related driving offense, because it's prior convictions that end up that make you eligible for felony charges. So if it's your first one, it should be a misdemeanor or ordinance. You can't be operating a commercial vehicle when you had the conviction, and you can't have any alcohol-related charges pending and no alcohol-related convictions after the offense. It also has to be at least 10 years since you were pled guilty or were convicted of the offense. So it can be very difficult to get an expungement of an alcohol-related driving offense. Excuse me. Again, you need to include all the parties that may have records related to the offense for the same reason I've already talked about, that they need to get notice, and my order would only apply to the agencies that have had notice. Again, the filing fee is $112.50, and you are only entitled to one expungement under this statute. And you cannot receive an expungement under the statute if you have a CDL or commercial driver's license. I don't think we have a petition for this available online. Typically in these cases, you would have an attorney help you to draft a petition for you. And usually most of the expungements that I see, people are working with an attorney, and that's why it's so great that UMKC has the Expungement Clinic so that they can help you through the process. But I have seen some successful pro se expungements, particularly of the arrest or convictions. And so it is possible to find those petitions and go through all the steps to qualify for an expungement. But in this particular one, we really don't have a petition that's already available and that you can just fill out and file. Any questions about the alcohol-related driving offenses?
Can I
Yes.
actually say a question?
Oh, well, this is the end. Oh, to the very
To
end.
the very end.
Oh.
But next time I'll get one to you.
This is the end of my presentation, though. Do you mind if I just answer it? Because I've got 5 more minutes. Okay, what was your question?
I just wondered if someone gets a misdemeanor expungement under this, does that take away one of the misdemeanors under 140, or are they separate?
No, it's a separate statute. So it's a separate, as you saw under 140, you're not even eligible for an alcohol-related expungement under that statute. This is a separate mechanism for expungement. There may also be a statute back there for the identity theft, and I don't honestly see those ever. So I didn't really feel very qualified to talk about that today. The statutes are available if you'd like to read through those, but I just don't see them filed. Yes.
Is it, what is this? Expungement of conviction? Guilty.
Of a conviction, typically. So I suppose if it was only an arrest, you could go under the arrest statute versus this statute, but this is more for a conviction, because the idea is that DWI convictions can be used to enhance a later, if you're later found guilty of DWI, it can be used to raise the level. So that's why these are kind of their own separate case.
I thought it only required a finding of guilt to enhance it in the future.
I'm not sure. I mean, I would think that once it's expunged, it's not a finding of guilt anymore on your record. So, anybody else have a question? Okay, well, thanks, guys. I appreciate it.
Thank you so much, Judge Rotella. Next, we will have Dean Ellen Sunni talking about the UMKC Expungement Clinic.
So, as you've heard, thank you. So as you've heard, expungement is extremely complicated. And I think that is what frustrates a lot of people not seeking expungement. And so I'm here to tell you there is help. There is help available. Okay, so let me tell you a little bit about who I am, who's this woman who is offering help. Tell you who I am and how I got to be standing here, and it will be very brief. My name is Ellen Suni. I am a professor at UMKC School of Law. I was a professor and dean at UMKC for about 40 years. Then I retired, and I have been working with what we call the Clear My Record project at UMKC. And that project has 3 prongs. Okay. One prong is what we call policy work. And really ultimately what that is working to try to change the law in Missouri so that these limitations on expungement can ultimately be reduced or increased depending on what it is. So for example, increasing the number of felonies and misdemeanors that can be expunged is part of what we're trying to do. Add certain offenses to the statute that are excluded at this point for no reason that we can really ascertain, and so on. And that's one part of our work. Another part of our work is we've been working for years, get closer all the time, to developing some technology that would allow lawyers to use and also eventually allow people to go online and be able to determine some basic eligibility for expungement so that you could enter your information, and then based on what you enter, you can ultimately find out, am I likely to be expungible? And the goal down the road, but this is a little further down the road, is that it would generate a petition, like you saw, for expungement that you could file in the court. So those are 2 pieces, but the third piece, which I think right now is probably of more importance to you, is that we have an expungement clinic. So what is a clinic? Law schools have clinics, and the idea of clinics is to essentially teach students, law students, to become lawyers. Now, the whole of law school is designed to do that, but a lot of it is in big classrooms, and clinics are in small groups where we work with the students directly, oversee their work, teach them, supervise them, help them. But the other part is that we do this in order to help fill a community need. And the community need that our clinic fills is a need to provide expungement services to people who can't afford paid lawyers. Okay? So if you're in that group and you're here interested in an expungement, you want to be talking to us. Okay, so what do we do? How do you get involved with the clinic as a potential client of the clinic? All right, so that's why we're here. We want you to learn as much as possible about what it takes to get an expungement, what the law requires. And you can, many of you can make a determination on your own just from this information. Well, and what you have in your hands if you picked up the materials, well, I was convicted of this particular offense and it's on the list of not eligible offenses. If that is the case, then currently you're not eligible for an expungement. That does not mean necessarily that you will never be eligible for an expungement, because the expungement law has been changed 3 times already since it was put into place in 2018. And there are several bills in the legislature right now. We've been part of 2 of them that seek to change expungement law. So if you determine today that, oops, looks like I'm not eligible, you should still check every year to see, and you can check with us to see if the law has changed and you would therefore potentially become available. But if you're here and you think, I think from this that I am qualified, or I think I might be qualified, but I have a lot of questions that I need answered before I can make that determination, we can help you with both of those things. Okay. And we can provide a little bit of that basic help today after the session. So if you would like to talk to us, we will have, I believe it's rooms downstairs, but you need to sign up at the table over here and indicate that you'd like to speak to us. And we will meet with you in a private room. We have law students here who are in our clinic or have been in our clinic. And they are what we call Rule 13 certified law students, which means they have applied to the Missouri Supreme Court to get certification so that they can assist people. And the other, Sydney, who you'll hear from later, and I will be overseeing the students in advising you today. You will not be a client of the clinic. You'll only become a client when you sign up and sign an engagement letter with us. But we think it's important for people to understand where they stand. We will only bring a petition for expungement if it is our opinion that the individual is likely to get an expungement. Okay, we don't want to create hope for people whose hopes are going to be dashed by applying for expungement. We want to make sure that the people we agree to represent have a case where we don't think the government side is going to object to the expungement, and where we think that we can make a good argument to the judge that expungement is appropriate and perhaps even required in a particular case. Okay. So one thing, you can talk to us, you can tell us a little bit about your background and what it is you've gone to expunge. We'll have some questions to ask you, and we can tell you, unfortunately, no, you're not expungible. Hopefully not. We can tell you, probably you are, but, and here's the big but, before we can take you on as a client, we need to do investigation into your background. Okay. And depending on what you tell us, the scope of the investigation may be different, but we will at that point tell you, okay, fill out our form, our intake form. And if you fill out our intake form, and we'll have computers down in those rooms where you can actually sign on and fill out the intake form now if you want, or we'll give you the link and you can fill out the intake form later. Okay, but that's how the process starts for you to actually become a client of the clinic, so that we can represent you. What is now? We will continue. We will advise you until we can make a recommendation to you of, very likely we're going to take you on as a client. Lots more questions. We will take you on as a limited client so that it allows us to get records from the courts that we can't get on our own. And possibly we may have to send you for a fingerprint check at Missouri State Highway Patrol. So if those things happen, we will take you on as a limited role client, because we need your permission to do certain kinds of checks in non-public records. Or we can tell you, we think you're expungible. And at that point, we'll have you come in for a full discussion with us and sign an engagement letter. That's when you become a client. Okay. And then we will assist you throughout the process. And what is the process? We, meaning, for the most part, the students under our supervision. So the students do the initial drafting. They are in the meetings, they lead the meetings with the clients. They do the initial drafting of petition. If you can't afford to pay the fees and want a waiver of fees, they will work on that with you. They'll take care of doing all the things you need that Sydney will be talking about later in case you're doing it yourself. The service process that Judge Roadcap talked about. Okay, so they'll take care of all of that work for you. We'll keep you updated as we do it. Once we have the petition written, we'll send it to you so that, we have you come in, you can read it over, because you're going to have to swear to whatever you say in that petition. Okay, so we'll have you come in, and eventually we'll have you sign the petition. Okay, and with a notary. We have notaries available to do that because we try to make this as easy as possible for you. Okay. So we'll then file the case in court electronically. We'll do the service. We'll see if there are any objections. If the government wants to object to your expungement, they have 30 days. And by government, the prosecutor, the Missouri State Highway Patrol, who is represented by the Attorney General, and any of the other people. If you remember, Judge Roadcap talked about checking off the agencies that are going to be the defendants in the case that you're suing and telling to close your records. Okay, any of those are able to make an objection. So if there's an objection, we'll respond to the objection, and then we will represent you in court. Okay? And we have 5 expungements that we've completed this past year, and we have 10 clients currently in various stages of that process. And if you become one of our clients, you'll be in that chain of hopefully getting an expungement. The process takes about 6 months, sometimes less, from when we agree to represent you until the end, because we have to get your petition done, we have to file it, we have to get the service done. Service it takes a long time till it all comes back and gets posted at the court. That's the point at which the 30 days for objection runs, it starts running. And then the judge in Jackson County, the judges set a hearing date when the petition is, shortly after the petition is filed. So you will know from really very early on when you're going to go to court. And unless there's some big glitch in the case, which we haven't, well, we had one in our first case, which was the court's fault, and they've changed rules as a result of it. But if everything goes the way we expect, your case will be ready for that hearing date, and you will actually, if everything goes the way it should, be expunged at the end of that hearing. Okay, so that is essentially who we are, what we do, and the process. There is no charge to you whatsoever for our work. Okay, so there are no lawyer's fees involved at all, because you're eligible for our services if you can't afford a private lawyer. Okay, and we will make that determination talking to you. Secondly, while there are fees, as Judge Roadcap talked about, the $250, and then the filing fee comes out to over $400, but we will work with you to see about getting a waiver. If you can't get a waiver of the fees because your income and financial picture doesn't allow it. But you do qualify as someone who can't afford a lawyer. We will represent you, but you will have to pay the filing fees. Okay, so questions? Or can we do it quick? Because mine's sort of specific, or oh, we can wait till later because we'll all still be here. Okay, well, I hope that was helpful, and you'll hear a lot more about a lot of the same things, but hopefully by the end, the idea is that you will have this information from a number of different perspectives, so you can sort of process it and put it together and really have a good understanding of what you need and what we can help you do with that. Okay. And don't forget, if you want to sign up, at the end of the program, sign up here so we know where to assign.
Thank you, Dean Zuni. Next, I am going to talk about how to file on your own for an expungement, how to file pro se. And I think this will be helpful for attorneys and everyone alike. Hang on, I'm gonna adjust this. Okay, that's a little better, maybe. Okay, so I'm going to talk about how to file pro se for an expungement, step by step. So it's not easy, but it can be done. In our work, we have checked the dockets of other cases, other expungement cases, and we have looked at a lot of pro se petitions, and so we have noticed where a lot of people go wrong, and hopefully this presentation will address that. And to be totally honest, we notice problems with attorneys' petitions as well. This is definitely more geared towards a pro se individual, but I think it'll be helpful for attorneys too. So here we go. All right. So the preliminary step you want to take is to make sure that an expungement will be worthwhile to you. There are some limitations that could make it not worthwhile to you. And if you go down the process and get really far along, it can be really frustrating and disappointing to then find out that it's not actually going to do what you had hoped. So the first limit to be aware of from the outset is that you can only get 1 felony and 2 misdemeanors total expunged over the course of your lifetime. Like Dean Suni said, we are involved in policy work, and also like Judge Roadcap said, this statute changes a lot. So hopefully someday that limit is not so low, but for right now, that is the limit. Some exceptions to this limit are if you get an expungement under a different law. So that could be another state's law, that could be another Missouri law. DUI and non-support have their own expungement statutes. So those don't count towards that limit. Also, there is the course of conduct exception, which is where if you had 2 offenses close in time, or 2 offenses that are charged in the same case, I say 2, but 2 or more, and they count as essentially only 1, the highest level of that. So if you have, and Judge Roadcap did talk about this, if you have a case where you have 5 charges, 3 felonies, 2 misdemeanors, it will only count as 1 felony when it's expunged. So after an expungement, some agencies still have access to your records. That would be the courts and law enforcement, child care, elder care, criminal justice employment, and banking and financial industry employment, because that's required by federal law that they can still see those. The total cost of 1 expungement can be up to $450 unless you qualify for that waiver of fees, which we will talk about how to exactly qualify. Okay, so then step 1 is going to be determine if your offense or offenses are eligible, and then determine if you are eligible. So in order for you to be eligible, you have to meet certain requirements. And usually these requirements can be met eventually if they're not currently met. So the first one is the clean waiting period. That means you need to wait a certain length of time, 3 years for a felony, 1 year for misdemeanor and infractions. And during that time, you cannot get any new misdemeanor or felony findings of guilt, excluding traffic violations. And then, so felony eligibility. These are always handled in the circuit courts, which is important to know when we get down to service, because you have to serve the court that you were convicted in. So if you were found guilty of a felony, you will need to be serving the circuit court, and that'll be likely the very court that you're filing in, because you have to file in the circuit court of the county where you were convicted. So most violent and sexual offenses are not eligible for expungement. And like I said, the limit right now is 1 felony, and you have to do that clean waiting period for 3 years before the filing of your petition. So once you file, look back 3 years, and it's that time period that matters. And then we have a list of some common felony offenses and whether they're eligible or not. I believe the judge said that stealing wasn't eligible, but it is in certain cases. There are some, if it's a Class A felony, it's not eligible. But I think that involves stealing something very strange, like some sort of crazy chemical off of, I'm not really sure, but it doesn't sound like something that's stolen very often. So some examples of felonies that aren't eligible, like I said, they include really the violent and sexual offenses. Forgery is also included in that list, which we kind of find strange because stealing and passing a bad check are eligible. It's kind of weird that forgery isn't. So that is something we're doing policy work on, and maybe someday that will change. Right now, it is not eligible. So now we're going to go to this crazy chart, which is probably too small for you to see. We did print out copies of it that are back there that you can check. So on this chart, it kind of goes over that first step I said, is my offense eligible? And with this chart, you need to do it offense by offense, not all your offenses all at once. You have to go through the process for each offense you have. And so you can look at that later. I don't think we can really see it right now. So moving on to misdemeanors. Misdemeanors can be handled in municipal or circuit court. And that I'm not sure what the best way to know, but I think calling the court and asking if they're the one who has your record is a good start, because you really want to know what court you were convicted in, so you can serve that court and make sure they get rid of your record. And you can get 2 total, and the waiting period is only 1 year for that. All right, so some eligible misdemeanors include the ones that are coming up here on the screen. As the judge said, first-time DUIs are eligible and they don't count towards the lifetime limit, but they do have different requirements. It has to have been 10 years and you can't have had any alcohol enforcement contacts during that time. Alcohol enforcement contacts include driving while intoxicated, refusing a breathalyzer, BAC limit is exceeded, things like that. Some not eligible misdemeanors include violating a protection order. A lot of the unlawful use of weapon are not included, such as when you're intoxicated and have a weapon on you, or if you bring a weapon into a protected location like a church or a school, those are not eligible. All right, and then we got the flow chart for misdemeanors too. It is pretty much the same as the felony ones. Similar requirements, but just a different number of the total that you can get expunged. And infractions. Infractions are low-level offenses like that are typically, they're always handled in municipal courts. Typically, a speeding ticket or a seatbelt violation, those are examples of infractions. And you can get an unlimited number of infractions expunged. And most of them are eligible. So I didn't even include a list here because it's most likely eligible. There is an exception if an infraction is the equivalent of a non-eligible offense, then it's not expungible, but I'm not really aware of any infractions that are the equivalent of ineligible offenses. Okay. Okay. So now we're going to talk about the petition and how to fill it out. Okay. So your first step is to gather your criminal record history information. Some free places to check are CaseNet. Kansas City Municipal Court also has a place you can check. And it's a really good idea to check there because if you have a unpaid traffic ticket, that will stop you from being able to file because there's a requirement that you cannot have any currently pending charges, and an open traffic ticket counts as that. So you want to make sure even those little offenses that you have that you've kind of forgotten about, check to make sure that they're closed. And you can do that at this link here, which we have resource material sign up list. So if you want to sign up for that and have any of this emailed to you, we can definitely do that. And just because your case doesn't show up on one of these, particularly CaseNet, does not mean it doesn't exist. There are a number of reasons it might not be showing up. It doesn't mean it's gone. And it doesn't mean that other agencies don't have it and aren't reporting it to background check companies. So another great way to check, but also not foolproof, is contact the court you were convicted in. And as the defendant in the case, you should be able to get access to those records. Not many questions asked. You might have to pay a fee for the clerk's work and the paper that it costs for that record. You can limit how much of the record you want. You don't have to request like the whole trial file, but you could just request the charging information and the disposition information, and that should get you all the information that you need to put in the petition. Then another option is to get a fingerprint report. These are very, very accurate, but they are somewhat expensive and time consuming to get, but they're not hard to get. And we have a packet of instructions on how you can sign up for that if that is something you want. It is, I mean, peace of mind is worth a lot. And if you get one of these, you should, all of your offenses and the correct information should come up. All right. Number 2.2 is identify the court you're filing. It's kind of confusing. So we have this map and we look at it a lot. It's actually the background on my computer, my screensaver. So you're going to think of the city where you were arrested, the city where you were convicted. What county is that city in? And then find the county on this map. And then you can see that they're shaded and grouped. So like 26, you can see is 2 counties, Camden and I'm not sure how to say that. Oh, I'm a bad Missourian. But Jackson County, for example, there's only one in the circuit and it's number 16. So if you were arrested and convicted in Kansas City, you would want to be filing in this 16th, circuit court. And leave the judge and case number boxes blank. Those are for the court. And they will input that information. The case number is to be determined. That is the case number for your expungement case, not the case number for the case you want to expunge. You put those, so leave those blank. All right, identify your case's party. So in a typical lawsuit, you got a petitioner first, some defendants. And this is no exception in the case or petition for expungement. So who are those parties in this case? The petitioner is you. The defendants, oh, so it's you. So you can put your name there where it says petitioner on the form. The defendants are the state agencies who are holding and reporting official copies of your criminal record. Your case for expungement is a lawsuit that essentially is forcing those agencies to close your record and stop reporting it. Petition for expungement. Okay. So that means in order to get a meaningful expungement, you have to serve all those state agencies that have those official copies. And we'll talk about who those are. One, Highway Patrol, always. They hold all the criminal records in the state. You have to serve them. They're a big one. So check that. The law enforcement agencies that arrested or cited you. Cited if it was a traffic ticket and you weren't, taken in or anything, arrested if you were. So we check that. And it could be either the county's sheriff department or a city's municipal department. So in this, if it was the sheriff's department, you would write in the county's name. If it was the municipal department, you would write in the city's name. A little note on Kansas City Police Department, KCPD, they are a little odd in the way they do it. And in these, they prefer to be referred to as the Kansas City Board of Police Commissioners because that's who handles all their lawsuits. But for this section, you can just write in Kansas City. The prosecutor's offices that prosecuted you. Check that box. So if it was in this county and if it was a more serious offense, it would be in the circuit court. And that means it would be the Jackson County Prosecutor's Office prosecuting you. If it was a more minor offense, like a traffic ticket or something, it was more likely in the municipal court. So it'd be the Kansas City's prosecutor office. All right. Then you want to include all the courts that convicted you. So since the lifetime limit is 1 felony and 2 misdemeanors, unlimited number of infractions, those offenses you might have been convicted in different courts. So if that was the case, if you had a traffic ticket that was convicted in municipal court and then say a possession charge that was convicted in circuit court, you would want to include both of those. And like the judge said, it's better to over-include than under-include. If your offense involved operating a motor vehicle, you're going to want to serve the Department of Revenue. If any of your offenses did, check that. And then the last one is a big one. And it's not on this form, which is unfortunate because that's kind of misleading, but the Missouri Department of Corrections. So if you were convicted of a more serious offense and were sentenced to probation or incarceration, then Missouri Department of Corrections has your record, and they are probably the most efficient at, well, they don't themselves report it, but they have this thing called a sunshine file that background companies scrape off the internet and then sell and report to employers. So if you were sentenced to probation or incarceration, and if it wasn't a suspended imposition of sentence, then you're going to be in that sunshine file. And if you don't serve DOC, they don't have to remove you. And then all the background check companies will still get your information. So you're going to want to check other and then write them in. And that is the address you should serve. But like I said, we can provide these materials to you. you just give us your email, we can send them to you, and make sure you get these correct addresses. All right. So step 2.4 is going to be these items 1 through 7. Read those over, make sure that you can swear to it, because that's essentially what signing this petition will mean. Those 7 right there. And a lot of people miss number 6. If you've never been granted an expungement before, check the box on the left. If you have had a previous expungement, check the box on the right, and then list the court and the case number. And make sure that that previous expungement wouldn't affect your lifetime limit. So if you already had one and you were trying to get another one and it would cause you to exceed it, it's not going to be granted. Then at the bottom, you're going to fill in your personal information. And then we're going to go to the back page, which is about what you want expunged. And you're going to fill in those 5 things. And you're going to go back to the criminal history information that you gathered. So this is a fake person. So this is what a CaseNet search results would look like. You go to this website that we have listed here, type, click litigant search. Litigant, that's a party in a case, and as a defendant, you were once a litigant. So click litigant search and then type in your name. If you have a common name, you might need to limit it to the county or put in your middle initial, because there are a lot of John Smiths and it can be hard to find what is actually your case. You can confirm that it's your case by clicking on it. Oh, and another note about those search results, oftentimes cases will have 2 entries and it's the same case, looks almost the same, but one of them has a -01 at the end. Use the -01. That's the actual one where you were convicted. The first one is this weird like preliminary step thing they do. But the -01, use that as the case number. Oh, I talked about that here. Okay, yeah. So as you can see here, they're almost the exact same case number, but one ends in -01. The -01 is the one you're going to want to put on your petition. And it will get rid of the other one as well. So, okay, so we don't need that one. All right, so, and in the petition here, we have the case number. You can put that right there. The court name, right there. The filing date, approximate date of charge. You can put the filing date for that. And the county or municipal of charge. We got Jackson here. Description of charge is not on this first entry that you see, but when you click on the case, if you click on the case number and you go into the case, you can find what a good description of it would be to use. So this is what it looks like once you click on the case. And you can see there are yellow tabs up at the top. Go to charges, judgments, and sentences. And also, if you're trying to confirm if it's your case, a good place to look is also the party and attorneys tab. Usually it'll have your name, address, and date of birth, and that's a good way to confirm that this is you. But for the description of offense, go to that tab there. And then we see here, there's the description. So you can use that, just put that straight into your petition. All right, so back to filling out this. So fill in for all the offenses that you think are eligible for expungement and for which you are convicted in that county that you're filing in. And then sign the petition. Okay, so now on to the stuff that really trips people up. And this is where a lot of petitions get, well, not this part yet, but okay, step 3. determine if you can pay those filing fees or if you're gonna need a waiver. As we said earlier, can be up to $450 for one. So it's a good idea to try and get those fees waived if you can't afford them. Okay, so here's some examples of some denied waivers. It's really the judge's determination. They can use a lot of different factors. Different judges do it differently. Some are more likely to grant them, some are less likely. But these are some examples from Jackson County where an individual has been denied a waiver. So here on the left, this individual, we were kind of surprised was denied because they qualified for SNAP food stamps. But they did have student loans for $5,000. They did have slightly more expenses than income. One thing Johnny, our colleague, pointed out is that it doesn't really add up in the sense that the income is only twice as much as the rent, and usually the income would be 3 times the rent to really make it make sense. And then we also have they're receiving child support but paying maintenance, and just so really want it to make sense. The judge has to look at it and say this looks real, and the form isn't the best at guiding you through that, but just the most important thing is to provide an honest, accurate overview of your finances. And here's some examples of granted ones. And I can't really say what they did that the others didn't do. Honestly, it was probably that they had different judges. I need to hurry. Okay. So a final, I just said that. Okay. Step 4, this is the one where a lot of people get dismissed and their petition isn't even heard. Their eligibility it doesn't matter. This goes wrong, you can't, the case cannot begin. So service of process. Like we said, this case is a case against those agencies with your record that is seeking to force them to close it and stop reporting it. So those agencies have to know about the case. They have to have a chance to respond. So you have to notify them, essentially. And how you do that is by serving them a copy of your file stamp petition. The clerk does that, and a copy of the summons. Once you file it, the clerk will prepare that for you. And essentially a summons is the court's order to the defendant to respond to this case, saying like, hey, what do you guys think about closing this record? And then they're given those 30 days to respond. Okay. So we have prepared a service instructions form, which there isn't one. This is new. We prepared this ourselves, and we've included some of the agencies that we discussed and their addresses, so you won't have to look those up. We are working on compiling a list of agencies and their addresses, but we do not have that completed now. So you will need to Google and find it yourself at this point. You can always call us or email us, and we can help you figure that out as well.
It's ready?
Yeah, definitely. Okay, so on the second page of these service instructions, you need to choose the type of service you want. We highly recommend certified mail because the agencies have to sign for it. So they can't say, oh, we didn't know about it. But if you send it just by regular mail, they can toss it and be like, we never got it. So we don't have to close your record. And you don't want that to happen. Certified mail is a little bit expensive. in Jackson County, the court will do it for you for $10 per defendant. A cheaper version that you could try, I don't necessarily recommend it, but based on our research, it should achieve what you need it to is first class mail and getting the tracking number. And then once it's delivered, giving that proof to the court to say, hey, they got my petition, they know about this case. And if you qualified for a fee waiver, then check the one that says I qualified for a fee waiver and you don't have to worry about it. The court has to do everything for you. Okay, and then step 5, confidential case information filing sheets. These are kind of annoying, but it's a lot of the information that you've already filled out in the service or the petition. You're just moving it over to this, but it's basically the parties and the addresses. So you'll need probably 2 or 3 of these sheets. And we have some pre-filled ones that'll be available in the resource packet as well, that just have like the case type code, which you wouldn't know unless you dug around and were able to find it, which we have already done, and we've put it on these forms for you. Okay. And then step 6, you're going to file those 4 forms in the appropriate court. All 4, you need 4. And then you're going to go to your hearing, be on alert. I don't think everyone knows that there's a hearing that they have to go to, but there is a hearing. You have to go and appear and testify under oath to your petition that you're eligible, that you've satisfied all your requirements, that you're not a threat to public safety, all that. So you will have to come back to court and be on alert for the court setting your hearing date. Usually they set it in Jackson County, about 3 months out. So I think I'm gonna skip this part unless everyone's like, no, but you can talk to me about it after for sure. This is legal Missouri with marijuana offenses being automatically expunged. I'll just briefly mention that misdemeanors that have been completed for marijuana possession are supposed to be expunged by June 6th of next year. And then felonies where you've completed your sentence are going to be expunged by December 8th of next year. And really, everyone is still trying to figure out what to do. I called, had some students call, and I called some courts yesterday and asked what was going on, if anything was different. And everyone's still just kind of trying to figure out what to do. And the courthouses haven't been swarmed yet by them, but that may be coming. I mean, they're supposed to be expunged. If they're not expunged, you have the right to ask questions. So now I'm going to turn it over to my colleague, Johnny Waller, who's going to talk to you about resources, community resources, both before and after, or if you don't qualify for an expungement. Okay.
Oh, okay. I don't need that. Yeah. All right, that works. Hey, everybody, I'm Johnny Waller, the program manager at UMKC School of Law for the Clear My Record Project and the Expungement Clinic. I had prepared some PowerPoint presentation slides, but this morning I deleted them due to the length of what I thought we would probably run out of time due to the extreme, wow. Yeah, that's not right. Due to the, it's all right. Due to the extreme length of the pro se portion, as you can see, it is very, very complicated, and it's a long. So Sydney did a great job explaining that, and hopefully you took some information from the back. In addition, when I was doing some research for the slides, it appeared to me that we continue to do the same thing, and that's to publish some kind of guide with a bunch of people's names on it, with a bunch of phone numbers, and there's no relationship there. And so I didn't want to come in here and list a bunch of people who I didn't know and put them on a slide and say, contact these people. At the clinic in the project, we have decided to include a resource hub. And that is something that is being built out currently. And that that hub will be built off relationships and referrals. And so if anybody had any questions about resources, they can always contact me. I was convicted of possession and possession with intent to deliver. So I've been incarcerated. I'm a directly impacted person, and I've been able to accomplish lots of things. So I have community connections, but it wouldn't be as beneficial to just put up some slides. There are resources out there. And I really want to point out, because I had a good conversation with my friend Candace Wesson. She runs the Help Kansas City. And so if you know any women who need any resources, they should contact Candace Wesson at the Help. At the beginning of the year, she will be opening a transitional house, one of the only transitional houses for women in Kansas City. And there's also Journey to New Life. And they provide those type of services as well. And so they have emergency funds, emergency assistance, transitional housing, and employment assistance. I found my freedom through entrepreneurship. Yeah. And so I am the former co-founder of Determination, Inc. Thank you. Fred went through it, he can attest it. He went through our program. So I found freedom through entrepreneurialism. So if anybody wants to become an entrepreneur, I mean, if you can't find a job, create one. That's what entrepreneurs do best. You can always reach out to Determination Incorporated and Cal Smith. Another organization who will become our referral partner once the resource hub is built is GIFT. GIFT is located at 5008 Prospect. They give out $10,000, $25,000, and $50,000 grants to Black-owned businesses on the east side of Kansas City. You do receive technical assistance. Hush Blackwell is in the building. They provide legal services. Lead Bank is in the building for your banking needs. Bank of Labor is also there. The Black Chamber of Commerce is there, and we're also bringing in a bunch of volunteers and other resources to help Black businesses. Another place, Serenity Pool, who is at the RU Prosperity Center. You can always go see her for jobs. Clyde McQueen, who's a friend of mine, they do some employment for people who are justice involved, so they have programs there. We're building a program with UMKC Talent Link for people to explore careers, especially those who are not eligible at this particular time to get an expungement, but more importantly for the people who do get an expungement, so they can begin to think about a new career path. And so as these models are being built out and grown, we'll develop key partnerships with our community, with people in the community who offer these type of resources, so we can provide a holistic way to help someone. Getting an expungement is one piece of someone's life. I have a pardon and an expungement. Like I got a pardon from the governor, and then subsequently I received an expungement. But once my criminal conviction was expunged, I really didn't even know what to do. Like I had been told no so many times that I didn't even understand what opportunities were available to me once I no longer had to check a box. And that's something that we're really working hard to try to create this holistic care for the whole person experience at the clinic. So it's not, it's working hand in hand with the policy work we do, working hand in hand with the attorneys there, but we do have a community facing side. And that's kind of one of the reasons, not the only reason I'm there, but one of the reasons that I'm there. And so if anyone has any community questions or resource questions, you can always reach out to me and contact me. Beginning in 2023, you'll see a real robust push effort to bring in these coalition of community partners to serve our community, because we're talking about people here. We're not talking about numbers. We're not talking about some guy on a spreadsheet from the DOC. These are real people, and we need to help the people in our community. 19,000 people a year are released from prison in Missouri, and we need to learn how to properly help them succeed in our community. Thank you.
Hi, I'm Jenny Garman. I know we're wrapping this up very quickly. I want to say this is the beginning. Jenny, I couldn't agree with you more. This is about relationship. This is the beginning of a partnership. I'm so delighted, so excited to get to work with UMKC School of Law and appear in my record project. We do have a few questions online. This recording will be available on the library's YouTube channel, and the resource list will be sent out to all participants. You should already have it, actually. I really want to say thank you all so very much, and we'll get to the questions. Thank you.
Cindy, I just want to answer two of the questions that came up before. Judge, there was a question about, can you get more than one arrest expungement? And I checked the law, and as best as I can read, not a definitive answer, but I don't see any limit on arrest expungement. The second thing is change of venue. Judge Roadcap was correct. It is either the county, a circuit court of the county where you were charged or found guilty. So those are the answers to the two questions before. If you have two DWIs, can you get the first one removed? No. The removal of DWI is a one-shot opportunity, period. Okay, what if the petitioner is currently incarcerated and cannot testify live? Okay, if someone is currently incarcerated for a 610-140, the regular conviction expungement, you have to have completed your sentence in order for you to get an expungement, and you have to have the waiting period of a year or 3 years. So for a normal expungement, the answer is it's not an issue. This basically, if you're thinking about Amendment 3 expungement, you don't have to have testimony as we read the constitutional provision. It's supposed to be fairly automatic. So a court may want you to testify. They can probably do it through video or however, but there are all these issues about Amendment 3 that we just don't know the answer to.
If someone isn't eligible for expungement, will we help with a governor's pardon?
No. We at this time only have the resources to do the 610-140 convictions and 610-130 DWI expungements. So the answer to that currently is no. Okay, one participant has been told by the court that they have to serve the agencies on their own. Court said the case could not go forward because the court said he did not have service. Okay, so the individual has to serve the agencies, but as Sydney pointed out, one way to do that is to request that the court do the service, but you have to pay the $10 for certified mail, or you can possibly do, we would not recommend doing just first-class mail. So you have to pay for it, but the court will actually do those mailings. Is that it?
That's all the questions.
Okay.
Any more questions from, yes, you, sir.
You have expungement. I have a criminal conviction in Canada, and it has been expunged. Would that have any effect on the jury?
No, it would not.
It should not. It depends on the age of the conviction.
Really?
Yeah, then it should not have any effect. And it-
20 years.
So there are these discretionary factors, as we mentioned, threat to public safety. And so that's why we hesitated and said, oh, well, maybe if it was really recent, they might consider it and say, might be a threat to public safety or whatever. But if it's 20 years old, it's hard to imagine that would.
Well, if it's 20 years old, we don't even have to list it in the petition.
With that, I'll go ahead and end the recording. Thank you all very much.
And we'll be around